I hesitated quite a lot about the structure of the lecture today, especially because of the fact that we are on Zoom. So instead of presenting this very structured paper that you will have to follow from beginning to end, I will cover mostly some arguments I make in the paper that I think that are relevant to this task of unlearning Zionism in general. So I hope it will really help us have a more vibrant discussion in general and to feel less Zoom fatigue. And because I present the paper like that, if you read Hebrew and you want the full version of the article, I'll be happy to share it with you. I do want, before, to open just with a few words about the overall project from which my thoughts on the Kfar Qasim massacre originated. My current project is an analysis of court documents, mostly transcripts and court rulings of cases in which the State of Israel persecuted members of its security forces for the killing of Palestinians. I term these cases acts of repudiated violence because of the denial of the dialectic position occupied by the state when it decides to prosecute its own soldiers, thus condemning the violent act while also taking its hands off it. After all, the whole idea behind these trials is eventually to legalize the daily violence that is not disowned as illegal. In that case, I consider these trials to be performative moments in which the state negotiates and sets out the limits of its legitimate and illegitimate violence. These trials allow to listen in a way to the state's corridor talks, because as much as the state can and is carefully tailoring the narratives these trials deliver, it has limited control over the discursive explosion, in Foucault's terms, that is taking place in the court and outside of it. The project originated from two complementary assumptions. The first assumes that despite the state's secrecy and its mechanisms of censorship, the state speaks, and if we are willing to do away with positivistic standpoint and set out our values regardless of the law's definition of legality and illegality as moral indicators, we can penetrate the state's internal logic and unveil its conditions of possibility. In other words, if we are willing to unlearn what entails a legitimate entry into the state and gain a privileged perspective over how the state perceives itself, we can see that the state is far from being as opaque as surveillance scholars would like us to believe. There are obviously specific methodologies one has to adopt to take this path. I won't be able to elaborate on that, but if it interests you, we can discuss it later. The second assumption concerns denial. Stanley Cohen's work is of great importance here. It allows us to see how informative denials of individuals or organizations can be. Beyond that, and that's something I picked up through my activism on sexual violence, the informativity of denial lies not only in what is told and how it is told, but in the sheer repetition over the same reasons again and again. In other words, there are specific denials for specific events. Within the field of sexual violence, a very familiar denial is the claim that everything was done in consent. When Israeli soldiers need to justify why they saw right to shoot, for example, a wounded Palestinian lying wounded on the ground, a central claim would be the sense of threat the soldier felt. We should thus be able to understand what are the conditions that construe these denials and render them so common. Why these answers are considered as acceptable as they are within a specific framework. In that sense, part of my project entails the examination of the extent at which we can render repetition in itself suspicious. So in what follows, I will offer a short presentation of the massacre and the trial, and then discuss a number of aspects I think are of essence for the process of unlearning in general and of unlearning Zionism in particular. These aspects include the memory of the Kfar Qasim trial, the challenge it poses, and the specific form of citizenship it unveils. On the eve of the Sinai campaign on October 29, 1956, it will be 64 years in 2 days from now, Israeli military officials decided that there is a need to ensure quiet on the Jordanian front. The potential agitators were Palestinian villagers occupying the area near the Jordanian border. In the interest of avoiding the information being leaked to the local population, the curfew was announced only some 3 hours before it was set to begin at 5 in the afternoon. Around the time in which the villagers were returning home from work. The local Mukhtar, to whom the Israeli communicated their decision, had no means by which to inform the hundreds of villagers working outside and due to return later that evening. 1 hour after the curfew began, 49 men, women, and children were shot to death by Israeli soldiers in the outskirts of the village, in compliance with the curfew and Colonel Shadmi's order to shoot to kill. Despite their carrying out their superior's order, 18 of the 11 soldiers who massacred the villagers were subsequently arrested, charged with murder, tried, and sentenced to 7 to 17 years of imprisonment. The 3 of the defendants were acquitted of all charges. In a way, this description can be enough. It reiterates the important elements of the massacre, so to speak, and the trial. If that is the case, then the matter is closed. The accused were found guilty and the victims were prosecuted. From a legal point of view, we learned our lesson. And when you review the scholarly work on the Kfar Qasim massacre, I'm talking about scholarly work in French, English, and Hebrew, because these are the languages I can read, you can really get the sense that it's a done deal. There is a general agreement over the facts that originates from the trial transcripts and the verdict. On a factual level, there are 2 open questions. Colonel Shadmi's trial that is still mostly closed to the public and resulted with a fine of 10 cents, and the question of Operation Kafr. According to Gadi El-Ghazi and Adam Raz, the massacre was part of this operation whose objective was to make Palestinians living in the Triangle area to flee to the Jordanian border and into Jordan, and as Israel did with Palestinians who flew for their lives in the past, then deny their return and reduce the number of Palestinians living in Israel. A secret mini Nakba. The declarations of the soldiers during the trial enforce this assumption. Another disagreement regards the number of victims. Israel counts 47, the Palestinians 49. The overall factual agreement, stemming mostly from the very detailed verdict of Judge Benjamin Alevi, renders the massacre and the trial into a very dense frame, almost as if we have a frame of a camera that simply captured everything and it tells us all we need to know. It leaves little to debate on, and I cannot but wonder to what extent the supposedly closeness of the massacre produced by the trial is what allows Israel to deny requests to apologize for it and acknowledge it, as well as dedicate a special national day for the massacre. I argue that it is this overall agreed factuality enabled by the state's decision to make public the majority of the documents related to the massacre that makes the Kfar Qasim massacre a challenge. Where there is little factual debate, the narrative of the events was already determined, and so was its meanings. Again, existing scholarly work is very telling in that sense. It focuses on the question of the manifestly unlawful order, the citizenship of Palestinians, and the memory of the trial among Jews and Palestinians. And excluding Shira Robinson's work, all these works rely on the core documents and the narratives it puts forward. Therefore, when I began to work on the Kfar Qasim massacre, it was clear that I need to unlearn these narratives and the meanings they produce, turning my gaze away from aspects that are important from a legal perspective and focusing on marginal moments, on issues that are non-issues for the state and the legal system, to unlearn the narratives and meanings of the Kfar Qasim massacre and the trial. Far from being a mere attempt at adding a narrative on existing ones, reviewing the trial's transcripts and verdicts and focusing on marginal moments, the relation between existing narratives and meanings over the overall question of legitimate use of state violence becomes clear. As Mamdani tells us, a legitimate use of violence entails that the violence should be rational, explained, one that we can appropriately situate within a narrative of progress. That is relatively easy when the violence is construed as a heroic act or one that stems from security necessities. But what can one do with an act of violence that is clearly unlawful and which forces the state, once it was discovered, to divorce itself from it? Letters sent by Israeli NGOs and private citizens to David Ben-Gurion once the massacre became known, demanding that those responsible for it will stand trial, clearly show that this violence, at least at the time, had no explanation and lacked an acceptable paradigm. The trial, in that sense, wasn't only an attempt to clean Israel from this shameful event, but also an attempt to situate the violence of the Kfar Qasim massacre on the right register, to detach it from all the supposedly justified and lawful acts of violence Israel commits daily. As Arendt explains in response to critiques over her work on totalitarianism, she insisted on not supplying an historical narrative that would emphasize what led to the Holocaust, because strict historical writings is always already a supreme justification of what took place. When an event is locked within a causative sequence, it can, regardless of how violent it is, to start going through a process of rationalization. The Kfar Qasim trial did just that. By focusing on the individuals who committed the massacre and considering their decision to shoot innocent people, the massacre could have been explained as bad judgment on their part, not as an event that lies on much deeper roots pertaining to Israel's own conditions of possibility as a sovereign state. Within this framework, Judge Levy's insistence on the equal belonging of the villages under the title of Israeli citizenship, the fact that his verdict was made to be a quick lesson on what citizenship entails, a verdict through which Israeli Jews were meant to learn that Palestinian citizens of Israel are equal citizens. In fact, this decision distanced the violence of the massacre from Israel's bleeding history that is constituted on a perception and employment of citizenship on the basis of passing like a Jew, not passing like an Arab. The order given to the border police soldiers was to shoot to kill, no questions asked. This order, which Judge Levy concluded to be a manifestly unlawful order, has a long history that doesn't relate to Israeli citizenship, but rather to Palestinian refugees attempting to return to their homes after the Nakba. In fact, the same order was employed against every Palestinian attempting to cross into Israel, regardless of his or her motivations, and whether they were armed or not. As Coren tells us, the majority of Palestinian refugees who were shot by Israel during the 1950s were poor Palestinians, hoping for better life. Yet, as indicated by Shal Hopke-Borkian, the infiltration law from 1954 rendered every refugee into a security threat. And from Israel's perspective, that was the case because the question is never the motivations or aspirations of the Palestinians, it's their own existence. In other words, under settler colonial settings, even the liberal idea of citizenship can be used to cover up the real origins of the massacre. Unfortunately, this is still one of the biggest legacies of the trial that never dared, intentionally or not, to look at the history of the order of shoot to kill, so constitutive to the Israeli state. I want to dedicate the last point to the specific form of citizenship which the Kfar Qasim trial unveils. In order to rule out whether soldiers could refrain from shooting innocent people on the day of the massacre, it was necessary to determine if it was truly possible to identify who among the people returning home that evening is a Palestinian citizen and who among them is a Fadain, a member of groups who were trained by the Egyptian army and attacked military and civilian targets within the border area of Israel during the 50s. The transcripts thus reveal long discussions in which the defense attorneys tried to show that, in fact, there was no way to identify a Palestinian citizen of Israel from a Fadain. They investigate army officers and ask them what differentiates, for example, a Palestinian citizen of Israel from a Fadain. One answers that he heard that in Egypt the Fadain wear sneakers. Others claim that a Fadain is armed, although at the time of the massacre it was impossible to get a clear view from afar of the person coming towards you. Some were at least honest enough to say that you cannot distinguish a Palestinian citizen of Israel from a Fadain, and that at any rate, the area of the triangle, and more specifically, the villages in which the curfew was held, was simply an Arab area. There were no Jews there. The lawyers keep on insisting and ask if they would see right to shoot an income tax official, for instance, had he been passing in the area during the curfew hours. The answer is clear, no. Also, when another army officer is asked if he knows what's an Arab bystander, he replies negatively. These discussions that, from a legal perspective, are almost meaningless, reveal in fact a form of citizenship that, contrary to Judge Benjamin Levy's wishes and illusions of liberal Zionists, is based on nothing more than the possibility of passing as a Jew and at least of not passing as an Arab. Considering that the political is constituted, according to Schmidt, on the possibility of identifying an enemy from a friend, something is clearly not working here, in a place in which it's impossible to distinguish citizens from non-citizens, where there are citizens and there are also enemy citizens. I will leave it to you to think if we could qualify the citizenship that is based on practices of passing as a sovereign failure, or rather as a constitutive element within Israel's sovereignty, then and also today. The failure to distinguish citizens from non-citizens, enemies from friends, is not limited to Palestinians, because it lies on the possibility of passing as a Jew, and passing as a Jew is considered as the opposing side of Arabness. Mizrahi are also targeted from time to time because they are mistaken for being Palestinians. In his work on the Mizrahi civil struggle, Roby mentions a number of occasions in which, during the 50s, Mizrahi men were shot by the border police because they were mistaken for being Arabs. A few years ago, another Mizrahi man was stabbed by a Jew who went out looking for Arabs to stab. And following the last arrest and imprisonment of Tamimi, members of the Israeli parliament were discussing the possibility that, in fact, the Tamimi family members aren't Palestinians, and proposed that they are actors recruited by the Palestinian Authority. The argument in favor of that assumption were Tamimi's light skin and eyes, as well as her blonde hair and American-style wardrobe, whatever that means. Having said that, it's important to distinguish the status of Mizrahi people in the early years of the Israeli state from the present. As Iris mentioned in her lecture, In the early years, Mizrahi people didn't simply look like Arabs, resembled Arabs. They were also considered as people whose loyalty to the Israeli state, due to their Arab origins, is uncertain, questioned. Today, I would say, unfortunately, our loyalty to the Israeli state is no longer questioned, no more and no less than that of Ashkenazi. The incidents I described, in which Mizrahi people are mistaken for being Arabs, originate simply from this perception of citizenship that is based on practices of passing, on resembling a citizen, in a place in which citizenship is still thought of through European appearance. Times have changed, and the hold of the Israeli state made sure that it would be much more beneficial also for Mizrahi to be on its own side. Thank you very much.
Thank you very much. I don't believe we're already finished. I think we could have all listened to you for another half hour at least and not even noticed. Wow, Revital, Madar, thank you so much for giving this very enriching and wide setting in which we can have conversation. I invite everyone to write their questions in the chat, and I'm happy to read them out loud without the names. And I will start with a question of my own, lucky me, because I think people are still thinking and writing. So, I guess the first question I would ask you is, can you maybe say something general on systems of peace/order? Are these integral to structures of violence and its justification as such? Would you agree with that comment?
That's a very big question, but
do whatever you want.
From my few years in France and my love of Fanon, it was quite amazing. I mean, a lot of I would say white people, because that would be the easiest, or liberal people, have a big problem with Fanon. On the one hand, we have this interpretation of Sartre in which everything is about violence, and the native cannot but be reborn through violence, which is a misreading of Fanon. On the other hand, a lot of times, I mean, I think every country has its own Zionists, and it doesn't pertain necessarily to their relationship to Israel. It really relates to some kind of taboo that you cannot bypass, something that goes against the status quo. And in that sense, there is this very intense attempt to pacify Fanon and to do away with all the violent elements of his writing. I think globally we see time and again, and perhaps especially these last few, what it is, in 2 months, in a month, we had 3 peace agreements in Israel. They are intertwined, unfortunately.
Thank you. Question: could you elaborate on the eventual analogies between your take on peacekeeping and the actual situation in France concerning Muslims and Islamophobia?
Oh, wow. I don't know if I'm exactly a specialist. I simply live here for the last 5 years. I can say only that I've been looking almost everywhere on the media, even on media, on like platforms that are usually more critical. I still didn't find anyone criticizing the French obsession to do caricatures of Muhammad as if this is the essence of the French idea of liberation and free speech. So I really hope I'm mistaken, and perhaps there are platforms I'm not aware of, but it is quite amazing to see how everyone are just saying the same thing. Laïcité is still considered this neutralized concept. So where do I find the relation between that and my work? That's hard to say. I really think that what I'm trying to do overall through the project is really to think about a state, or more even a sovereign power's conditions of possibility. So in that sense, every research we would do about the state would require to historicize it and to put it in the specific context. It means that I cannot just take what I know about Israel and consider it valid for another society.
Thank you. Can you tell us more about the sources / methods you used for your paper today? And in particular, if you are looking at other moments where the category of infiltrator and citizen emerge together.
I'm really, my overall project is an analysis of 3 cases of this nature. So there is the Kfar Qasim massacre, there is the event from 49, Mishlat Mirim, in which a Bedouin young girl, we don't know her age, was gang raped and murdered by an Israeli battalion, really just close to the border at the time with Egypt. The third one is the 2016 shooting incident in Hebron. And it might be a bit of a frustrating answer, but I'm trying to really approach each case as from its own limits. So there are some resemblances, but for instance, this Bedouin girl, of course, that there was an order that was given to all the units that were positioned next to the border on 49 to shoot to kill. And through the trial, you can see that they consider the order to shoot to kill. They don't consider the order to shoot to kill every Arab, women, children, whatever, every Arab that passes by as illegal at the time. What they consider as illegal is the command given by the officer to one of his soldiers to shoot her after they kidnapped her and raped her for almost 24 hours. But there is, they give this order to shoot to kill, and then the day afterwards, when they're given the written order, then they change it and they say that you shouldn't shoot children and women. So there is this difference between the written command and the command that is given orally to people. But there is really no question of citizenship. And of course, also in the 2016 shooting incident in Hebron, there is no question about the citizenship, the status of Al-Sharif. Is simply a terrorist, is considered a terrorist through the trial, although he never stood trial in himself. He wasn't prosecuted, obviously he was murdered. So I think it is interesting to see, though, that in the early years of the Israeli state, it seems like Israel is more preoccupied with the international community. But also, even in the Kfar Qasim trial, on the one hand, we have all these letters that are sent to Ben Gurion from citizens, from NGO, telling him that's a terrible event. They have to be tried, and the trial has to be public. But then, when the trial is over and they got their punishment, they were imprisoned, then you have these letters that are sent and like, listen, yeah, they did something very bad, but we shouldn't react so aggressively to them. So in that sense, it was really interesting to read it in relation to what happened around the 2016 shooting incident, in which we know that there was a very big support for Alora Zaria among citizens, among politicians.
Yeah, maybe I can add to that another short question. When is a hero just violent and when is it legit? And is the only difference then the law, or is the difference being caught?
I would have to ask from whose perspective. I mean, I obviously, as I hope it was clear from the short lecture, I don't think we can consider the legal spectrum to be our indicator. And especially when you see how the open fire regulations, for example, is really what structures this, the question of how the event is going to be denied. Okay, what's going to be the response for the, so it becomes really, I'm just working now on the 2016 shooting incident, an article on this event, and it becomes clear that from a legal perspective, the death of Al-Sharif is the most irrelevant issue in the trial. And the trial is construed entirely from the perpetrator's perspective. That's it. But at the same time, it seems that most of the time these events will go, there will be a process of prosecuting those involved, et cetera, because it was found out. I mean, there was no intention on Ben-Gurion's part to have a trial in the beginning. He thought he can cover it up. I think the most interesting events are really these perverse moments in which people from the army cannot bear the violence and they decide to speak out. They are very rare, but it's interesting to see that it exists, but that's really it's not what happens most of the time. Most of the time it simply gets out to the international media, and then they are forced to do something about it.
Thank you. Could you say something about how you came to this project? What was your initial motivation? What sparked it?
So I'm obsessed with sovereignty. It's something that, because I was doing my master, I was a student of Adi Ophir, and I worked with him on that topic, and then I left it for a while. And it started from the realization that in philosophy we take this relation between sovereignty and violence as an obvious one. And I'm not very much contesting this relation, but I do think that something else happens in the moment in which the state acknowledges the violent act. Because most of the time we are discussing and analyzing the state's use of violence at moments that the state doesn't necessarily acknowledge it as such. I mean, either there is a denial of the event, it didn't take place at all, or it was legal, it was justified, etc. And I thought that these events perhaps would allow me to go into how the state negotiates these limits, and how, in fact, they transform in a way the sovereign power in question.
Next question, thank you. Did you find other mechanisms than racial profiling and passing to assert state sovereignty?
That's a very interesting question. Because I've never thought about it as a mechanism to assert state sovereignty. So I'm thankful. I don't know who asked the question, but I'm thankful for this idea. But I am thinking of looking really more deeply and hopefully with other scholars on really this idea of citizenship that is based on passing, and how because I think we are all using it very, very often. I mean, our idea of citizenship is really doomed in that sense. We live in France, so we are very used to, we usually, when we lived in Paris, it was mostly in neighborhoods with a lot of immigrants. So friends would come and they're like, there are no French people in your neighborhood. Because they are all Black, Asians, and I'm saying it, and at the same time, I mean, I think it's really embedded within us, the idea that nationality comes with a specific appearance. Whether it really helps to strengthen, withhold state sovereignty, that's a good question. I would say just like that, yeah. Because if I would think about all the abstractions that are required to think about a nation, so of course a specific appearance would be a very important feature within this process.
Thank you. I'm always impressed by our speakers that have answers to all the questions, and they're very different, and some are more personal and some are thanks for that. And I'm gonna ask another one of my own, as long as there's none in the chat. And also you can see in the chat who's asking the questions. I purposely don't read the names just in case people don't want that. Yeah, so maybe we can stick with, I mean, it's somehow related. Was the you call it the potential agitator? Was the image of the potential agitator, has it changed over time? If yes, how? And was it also sometimes adopted, actually?
I need a bit of clarification on this question.
So I'm thinking now of like Tnuat HaShomer, and having like on one side this image of this is the person you should be afraid of, like the image of the agitator, right? Mm-hmm. Where the potential agitator is the infiltrator, and in the same time there's also an adaptation of their culture or of their appearance to become or to justify some sort of local belonging. It's not exactly what you're talking about, but I wonder, like the image of the agitator, is it like, has it changed over time? Do you see there is some developments? And also if you would wish to comment on that. If not,
I don't work on this specific issue, so I cannot really give a reliable answer beyond my intentions, and I don't beyond my assumptions, so I don't think it would be fair.
Okay.
So you see, I couldn't answer a question.
Sorry, I also didn't form it very well. So next question. In the Jewish Israeli society, many of us are civilians and soldiers, either before civilians and then soldiers, or civilians and soldiers at the same time. How would that maybe influence the discussion, or also the objectivity maybe of the courtroom, where everyone also used to be a soldier?
I think it is it's in the film The Rule of Law that one of the judges says, is honest, is like, it's very problematic to have like a Palestinian coming into court under the accusation of committing a terrorist act, which is like something that targets me as a Jewish person in Israel, and to really just be fair and be able to, I think that you see the relationship, the fact that most of the people in Israel go to the army. I think you see that in these trials, mostly when it gets to the punishments, I mean, the specific verdict they would entail. So then immediately they're taking into consideration the fact that as soldiers, you are already in a situation of contributing, to the state. You're already doing sort of a voluntary work. So that's, and of course, in the 2016 shooting in Hebron, it was very clear with the identification of Elor Azaria as our child. It happened, by the way, also with the group of young men accused of rape in Cyprus. They all became in one moment our kids, which is also, and they were before their service. They were about to start their service. So yeah, it's something that is really strong in Israel, I think, in general.
Thanks. Next question from the audience is, in your opinion, does the Israeli legal system take itself serious when it comes to bringing justice for the Palestinian, or is the court just meant to be for PR purposes?
I think it's neither, actually. I think it's really, I'm working on a paper now with Yael Berda, and it's one of, there is this tendency the last few years, there is a lot of propaganda coming out of the army. So one of it, there is the military prosecution decided for Israel's 17th Independence Day to ask the soldiers to write about these important events for the military prosecution. And that's a very interesting project to look at. It's online, you can all visit it. And we were really trying for a very long time to understand why are they doing it. I mean, why are they writing about these cases? I mean, the majority of them don't involve Palestinians, but there are quite a lot that involve Palestinians. And it seems to us that, and you can be in disagreement with me on that, of course, but it seems to us that what is important for the military prosecution is that it would simply be by law. What is the content of the law is less important and less relevant. And that's how we came to it, because there are this very strange situation where, like, the soldier writing this text about, it would say, yeah, it was a very important case, and you see how the judges really gave a very important decision here, considering a Palestinian issue. But eventually, but then, like, the verdict is really, is humiliating, and there is no contradiction for them. So it seems like the mere fact that it went to trial, it was tried, it was by law, even if the law itself is problematic, is really what helps them sleep at night, I don't know, feel comfortable with what they are doing.
So what does the justification of some violence under the law and the delegitimization of other violence that becomes unlawful have to do with the democratic part of the title of the State of Israel?
Can you repeat it? It was,
So Israel defines itself as Jewish democratic state.
Yeah.
What does legitimate versus non-legitimate violence have to do with holding on to this Jewish the democratic part of the title of the state?
I think it's essential. I think it's really essential. I don't think I would say anything very new here by claiming it, but because the world is looking. I mean, I think Israel's status in the international community is a very, very it's a very complicated one, because on the one hand, we are talking about a state that is a strong state, a wealthy state. And although we don't have any border, I mean, we never really decided on our borders. So we can say like the borders are contested, and they are contested. But the question is by whom? And the international community is, you know, they can give declarations, etc., etc. In general, they're not doing anything. So Israel is really in this strange situation in which it relies also a lot economically. I'm sure Shir Hever knows much more about it than me, about export and its relations with other countries. Perhaps now with all these peace agreements, we can just decide to let go even of the liberal image, because what does it matter anymore? But eventually, I think it's really essential to do these trials, because you can see with the 2016 shooting that the reactions internationally were very hard. But then, you know, it went to trial. There was a bit of criticism about the fact that Elor Azaria was imprisoned simply, like the verdict was simply 18 months. That were reduced, of course, afterwards. That's what happens all the time. But it didn't shake anything. I mean, what would have happened had Israel wouldn't try anything? That's a good question. But as we know from the very important work Yesh Din is doing and B'Tselem, I mean, it's a small fraction. So most of the time we don't prosecute.
I invite the audience to keep bringing in your questions. We're going to shortly finish up. So if anyone wants to ask one or two more questions, please welcome. I'm coming back to this idea of making trial because one has been caught. And I wonder, what does that have to do with freedom of academy as a watchdog for state institutions? If you want to give a comment on that, of like who catches who, and where are responsibilities within those spaces?
I'm not sure I will answer your question, but I will share a short story. Because yesterday evening, I went into my Facebook that is closed now because I have to submit my PhD in a few months, so I'm not allowed to go there. But I went in just to let people know of this lecture. And then I found a message from a military historian that I quote in my paper, and he told me the day he and another military historian found the final proof that Operation Kafr was in place, but that in fact there are other reasons for it. Eventually, I convinced him to send me his paper, and it really triggered me, because I can't say more about that, a lot about that, because I was swore to secrecy because it's under review. But it was really interesting that their claim is that actually Operation Kafr was intended to trick the Egyptian. That because that the idea was to make it look like there is action on the Jordanian border, but in fact, the idea was to attack Egypt. And that no one intended the order of shoot to kill given to these units in the villages in the Triangle area. No one intended them to really shoot the villagers. So it was this perverse outcome that no one intended to, and in fact it was a deception plan, And I was really dazzled by it because, of course, on the one hand, of course, Israel gets out perfectly because suddenly shooting Palestinians is a perverse action in Israel. We know it's not, unfortunately. On the other hand, I was asking myself, why is he even writing about it? I mean, he's a military historian, clearly very Zionist. The man who wrote with him is teaching in a military academy in Israel. I mean, these are people from within the system. So I think that's really intriguing. I mean, I feel like there is something about the Zionist soul, I don't know, a Zionist consciousness, I don't know how to call it exactly, that is really interesting to me because I don't understand it. That's the fact of the matter. I simply don't understand it. I don't know. I mean, again, none of us is a rational being in the sense that we would like to think. So perhaps we can just say, okay, Zionists are like everyone, like all the other. But still, it's really interesting. I thought maybe part of it is really because it has to do with the past. So not only eventually Israel comes out okay because they didn't intend them to shoot the Palestinians, and then they were like, oh wow, why did you shoot them? We just told you to shoot them, but you weren't supposed to shoot them, something like that. And also because in general there is this, it's something that I picked on when working on Kfar Qasim. It's like there is this national mission of saving Ben Gurion's name, and they will do whatever gymnastic they have to do in order to make sure that Ben Gurion is okay. He didn't cover up. He did that. So yeah, not an answer, like I said.
But a great story. Thank you. Okay, I see there's one last question that I missed. Adding on the mechanism question, what expression, to your opinion, does this mechanism take in relation to the Jewish citizens of Israel, if any? And I think that's sadly our last question, and then we'll start wrapping up.
Okay, very good question. I think we should ask about which Jewish citizen, because we are not as homogenic as Israel would like us to believe. But I think I feel it's a bit hard for me to answer because my instinct would be to say, yeah, of course, we as Mizrahi, we pay a price for it. Whereas I don't know, light-skinned Jewish people simply enjoy this privilege, etc. But that seems like too much of an easy answer. And on top of it, as time goes by, I feel like we need to revisit the narrative we have about Mizrahiyut in Israel in general. I feel it's like it's frozen in time. In a way. So very often we will see the same theories applied, same theories that were written in the 80s, in the 90s, applied today. And I think the status of Mizrahi people changed greatly. So I really appreciate in that line works that are being done on Mizrahi people from middle class or upper class and stuff like that. Not to say that there are no differences, economic differences, cultural differences, and opportunities among the groups, but that politically something changed. And I think as a Jew, we simply meet it daily. Every time we are not asked a question when we go into a public institution, we feel that our citizenship lies on passing. And when we are asked, we know that it's not clear. I mean, I'm asked when I'm entering the airport with a taxi, and then they add to the appearance, of course, my accent, and then they are very happy and I can go in easily. But yeah, It's something we feel daily, I think, even if we are not asked. It's also
Revital, Madar, thank you so much. It was a true pleasure and honor to have you part of our program and to listen to you speak. If you have any last message you wish to share with us this evening, or something you want to ask us, you're welcome. I think we are officially wrapping it up. And yeah, here come all the thank yous. So if you want to have the last word, you're welcome. And thanks again.
I would just like to say thank you for the invitation. Thank you for all the questions. And keep on with this beautiful project of unlearning Zionism. I wish us all to unlearn everything we learned there. So that's it.